Hello, DAF families. I'm Sharon Ackah. I serve as lead counsel for education law within the Department of the Air Force. I am happy to bring you another series of education law videos intended to strengthen your toolkit for special education advocacy. This first video introduces Section 504 of the Rehabilitation Act of 1973 and begins to define the key requirements for its applicability. In addition to discussing eligibility, the video offers clarifications on terms such as impairment, major life activity, and substantial limitation. We will also talk about general considerations to keep in mind when discussing Section 504 accommodations in an educational setting. As we move through the series, we will talk about 504 meetings, 504 plans, and disciplinary issues under Section 504. We will also discuss a bit about filing a Section 504 complaint and a few of the unique challenges that face us as military families. So here we go. Section 504 prohibits discrimination against people with disabilities in programs that receive federal financial assistance. The Act covers a broader range of disabilities than the Individuals with Disabilities Education Act, or IDEA. As I mentioned IDEA, I do hope you've had an opportunity to take advantage of some of our prior videos which discuss IDEA, IEPs, and the requirements for receiving services and accommodations under this federal law. Just as a brief reminder, IDEA governs the identification and eligibility of children with disabilities, as well as the provision of special education services to those students who qualify. Now let us get on with our discussion of Section 504. Here are some key points. While our focus is on applicability in educational settings, Section 504 is actually a civil rights law. Under Section 504, a child with a special education need cannot be denied aid, benefits, or opportunities to participate or services from federally funded programs. Private programs may not exclude or charge participants more unless justified by substantial increase in costs to the program itself. All children with disabilities who receive special education and related services under IDEA are entitled to services and accommodations under Section 504. Okay, let us break down the details. To whom or to what entities does Section 504 apply? Well, it applies to any preschool, elementary, secondary, or adult education program or activity that receives federal financial assistance. This includes extracurricular activities and not just core curriculum activities. Who is eligible for the protections of Section 504? Well, the answer is any person that has a physical or mental impairment which substantially limits one or more major life activity. The person must have a record of such an impairment or be regarded by other persons as having such an impairment. So what does this all mean? Substantial limitation. Think of this term very broadly because the law favors expansive coverage. The standard is not intended to be very demanding or to require extensive analysis. The law does not require the impairment to be active. It can be episodic or even in remission. Now to the term major life activity. Caring for oneself, performing manual tasks, seeing, eating, hearing, sleeping, walking, standing, sitting, reaching. You may not think about these because they're second nature to us, but all of these things are major life activities, just as lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, writing, communicating, and interacting with others. Once again, these are all examples of major life activities. Now, the operation of a major body function, such as functions of the immune system, special sense organs, digestion, breathing, circulation, musculoskeletal systems. Again, these all constitute major life activities. To name a few, here are examples of physical and mental health impairments. ADHD, or attention deficit hyperactivity disorder, asthma, anxiety, depression, food allergies, obesity, cancer, diabetes. Examples of accommodations include medical supplies, nutrition, technology, communication plans, and modifications to extracurricular activities. So, as I said, we would discuss a few general considerations in addition to some of the specific definitions that we just discussed. Here they are. There are fewer legal rights with 504 plans than with IEPs, and schools have fewer legal obligations under Section 504 than under IDEA. Oftentimes, a school might offer a 504 plan when a student is found to be ineligible for an IEP. As a quick reminder, because I'm not sure that I said this in this video, IEP, Individualized Education Program. Okay, another consideration. It is more difficult to qualify for an IEP because IDEA requires at least one of 13 specific disabilities, which results in a child's need for special education services. On the other hand, Section 504 is much broader and includes any disability. Unlike under IDEA, there is typically no formal progress monitoring for 504 plans. There are different standards and requirements for children placed in non-public schools by parents and those placed by school districts. So let's recap what we've just discussed. In this video, we have learned Section 504 is a civil rights law that protects people with disabilities from discrimination in federally funded programs. We have also learned that it is broadly applicable in a public educational setting and applies to any person that has a physical or mental impairment which substantially limits one or more major life activity. We've talked about the terms substantially limit and major life activity, as well as some examples of impairments that can trigger 504 protections. We've also done some comparisons of 504 and IDEA. But as we move along through the next few videos, we will dive a bit further into comparing these two federal laws. If ever you have questions, please visit your local legal assistance office by scanning the QR code on your screen and finding your legal assistance professional who is ready and waiting to assist you. Thank you.